Now, the Office of the Public Protector presented its 2022-2023 annual report in Parliament yesterday. Now, it contains invoices on impeached Public Protector Busiswe Mkhwebane's rental and legal fees. Now, these are amounts that she's expected to pay back from her pocket, and also contained in this report is a question mark on whether the advocate should be paid her end of service gratuity. Now, to help us unpack all this is legal practitioner Mpumelelo Zikalala. Thank you so much for making time for us this evening. We certainly appreciate it, Mr. Zikalala. Now, besides being found guilty of incompetence, misconduct, and subsequently being impeached from office, now there's this possibility that the former public protector could have unfairly benefited to the amount of 2.1 million rand on some issue of accommodation. Now, is this just a normal handover, takeover that is happening in the public protector's office, or is this all because of the impeachment process?
Good evening to your viewers. I would say it is normal. Well, from the accounting officer, which is the current acting public protector, she's obligated by law to look at over all the finances that are there. The Public Finance Management Act dictates that she makes or she is accountable to Parliament and also to us South Africans. So one of the things that they're going to do is on all the amounts that have gone out of the bank account of the public protector, what amounts belong to who, where those amounts budgeted, is the value for money where those amounts have been received. And if there's no value for money or it hasn't been authorized, then she's obligated by law to investigate those instances in which those amounts may have been paid and take all precautions and all measures to make sure that she's able to recover any authorized amounts that have been made. So the current step that she's doing is a step which is completely normal, a step that she's obligated to do as per law.
Right. So we heard yesterday from the CEO of the Public Protector's Office that they expect to then finalize collating all these figures in the next few weeks. What process can we expect to then unfold in trying to resolve these issues and making a determination at all whether the former Public Protector is liable for these costs?
The first one is the investigation. The PMF, the Public Finance Management Act, says that do an investigation first. After that has been done, send it to a special committee if that committee does exist. If it doesn't, use the accounting officer who will have to take over from there and simply raise a debt and say to the person that has incurred or caused the unauthorized expenditure to be incurred, please pay back the amount of money in which we've been paying from our coffers, because we do not budget for this amount of money, and certainly is not going to be incurred by the office where you are the person that has solely benefited from. So we're opening up a position or an opportunity for you to come back and substantiate. Maybe you can come up with a plausible reason of why the amount was spent, but if there's none, then you have to pay back the money. Once the debt has been raised, all the normal legal processes are then there. Either acknowledgement of debt is signed, in which that makes the process much, much easier. If not, then unfortunately you have to go to the courts in order for you to recover the amount of money which is in dispute. Now, taking the amount of money which is being talked about now, running into millions, you do see, or this matter may even move up to the courts, in which the public protector or the office of the public protector will then say, we're in need of this particular money. There's no other avenue in which we could have utilized to make sure that you're able to pay this amount advocate in Mkwebane. So on those basis, please, let's go to court and see whether this dispute can be settled by it, either amicably between the parties, or it has to be by order of court, in which you'll then be forced to pay the amount that you've caused the office of the public protector to incur.
And all of this really sounds like such a cumbersome process, as is legal processes. Now, if anything is to go by from how we've seen that she really fights back when it comes to these legal processes, as she should, she has the right to do that. How do you see this panning out, and how long do you think this process is likely to take from the time this investigation is coming to place and then goes through the legal court process to where we can really get some kind of answers around this?
It can take a bit of amount of time, but depending on whether it's going to be done in-house or maybe external legal practitioners are going to be sought. A collection system dealing with this matter can easily be sought. Even debt collectors can be engaged, and they always work on a no collection, no payment approach. It makes it easier when it comes to the procurement process. But to timeline-wise, you are looking plus or minus between 6 months to a year up until this matter is actually at the table of the court. And then once that has been done, if there's any party which is aggrieved by the outcome, it's within their right to say we are going to appeal the matter. And they can do that up until they get to the Constitutional Court. So roughly speaking, maybe between 6 months to a year to even 36 months up until this whole process is done and dusted. But what's going to matter the most in this case, if we are assuming into the amount which is in dispute, I do not think that the Office of the Public Protector is going to want to turn a blind eye to any expenditure which runs into millions. And certainly when they need to account back both to the AG and both to Parliament, they must come up with a plausible reason on what steps did they engage in order to collect the amount in dispute. If it is found that they fail to employ proper measures in the collection of a particular amount, they may find themselves in trouble and even contravening the PFMA. So it's important that they do all the processes regardless of the amount of time which is going to take, just to make sure that they stay in the right or the correct side of the law.
And you've already alluded to what would have been my next question, but I still want us to ventilate this a bit further in terms of the grey areas that could be encountered throughout this investigation, particularly because she was the head of the Chapter 9 institution, not particularly an employee. What would be a watertight case that those that are investigating and bringing this case forward would have to plug in terms of any loopholes?
Regardless of the position that she occupied, any government institution works on a budget basis. So a certain amount of money is issued, the budget is allocated. If anything outside of the budget is incurred, you must be able to find a plausible reason of saying, why did you go beyond this particular budget? Is there a environment that maybe would have sufficed, or is it a process where you've simply engaged in over expenditure? If that's the case, then come back and pay the amount of money. The law is very clear. It even prescribes to accounting officers as to how they should treat themselves and how they handle the budget of the departments or even the entities in which they are supposed to work in. So just as long as she's able to account for the money and say there was value for money, it was an activity in which they needed to engage in, she's going to survive. But if it is found out that there's reckless expenditure that has took place and there's no value for money that has been received by the office but received by her, then unfortunately she should have to pay it back.
Then again, of course, coming at the back of that impeachment process that went ahead and found her to have been impeached, the talk of her pension and all the benefits that come with that office that then she's likely not to receive, is that a black and white issue once again, or is that, off the table completely?
It's not a black and white. I think there's a bit of a gray area in terms of saying what would make you qualify for the particular gratuity. Is it a situation of saying that it forms part of your package, or is it performance based? If you do well, you exit the particular office without any black cloud hanging over your head, then you're going to qualify for it. It's certainly something in which I think the Department of Treasury will have to look into in terms of saying, did it form part of the package? Was it the normal salary that she would have been paid? If you then say that she does not qualify for it, is it a benefit which was dependent on performance, or by virtue of her being there, completing the actual term which has been incurred, then she would have sufficed, or that particular amount of gratuity would have been accrued to her. So it is going to be a grey area, and I think it is a matter in which government will need to look into in terms of saying, in instances where accounting officers have not performed in a manner in which maybe Parliament would have liked them to perform in, what sort of gratuity should accrue to that particular individual? Are you then supposed to get your normal salary as normal, or all the other benefits which have accrued to you by virtue of the position that you occupy must then be given to you regardless of the fact that you left that particular office under a grey or dark cloud?
So while I know that we spoke about the current issue of the accommodation, some part of protection that you needed in terms of a security, but that is not the only issue when it comes to the amounts that are being collated. I mean, we've seen her having to endure personal costs to some of the legal matters that she has faced. And also, her legal fees while she was going through this impeachment process, all of that is going to be looked at in retrospect to see if there's some monies that she needs to pay back. Is it really practical that she would be able to then pay back if at all she is found liable? I mean, there's a huge amounts of money that, once again, like you've already said, run into millions.
For the sake of compliance with the law, of which we don't have a discretion whether to comply, we have to. You need to come back and say, especially to the Auditor General, I've tried to collect this amount of money. I have it on plausible or on reasonable grounds and from a legal expert that is provided to me with a legal opinion saying that we cannot be able to recover this amount of money, or the recovery of money would be an example of chasing bad money with good money. So we're not going to engage in this particular process. But you can't simply assume that this individual is not going to afford the 2.1 million which is in dispute or which is currently being talked about. So at least start the process, or at least start the investigation, determine the actual amount that is being owed, if there is an amount which is owed in any case, and if there is, start the normal collection processes which are there and which are utilized on a regular basis. I've stated the example of debt collectors, even legal practitioners or attorneys' offices can be utilized, and this start the process of going to court and checking what exactly can you be able to get. The worst case scenario being, at least end with the judgment against the name of the person that you're pressing against, and simply say we have to execute using selling execution or attaching movable or immovable property. There's nothing, the value of the amount which is not enough to satisfy the debt, rather than keeping quiet and letting it be. The worst people which are not going to be happy about it is the Auditor General and also Parliament, because the number one question would be, what activities or what steps did you take to make sure that you're able to recover this amount of money?
Makes quite a bit of sense. Thank you so much, Mpumelelo Zikalala, there for your insights. Certainly helpful to try and get us a clearer picture of what to expect as the story unfolds with the impeached public protector, Busiswe Mkhwebane. Quite huge amounts of money that she may have to pay back while she was in office, incurred while she was still in office.